We have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred. Apparently, no one's consulted her regarding this
You
thing.
told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
So, okay,
There was never a suspension on his license at all. He's been good to drive.
but he was also drinking.
But
The concern was that he was drinking. And
Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible.
Did it just become eligible, or when was it eligible? You know what, let's do this. I have a line of people, I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had to
more
go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at,
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
what day was it lifted?
4/2/2025, from what I can see on the license. It's the ICC.
And what are the days that he's alleged to be driving?
The second judge, let me double check.
And does he have an interlock as well?
Yes, Judge, yes, interlock, he was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension ever. The state told you that. That's why you
Was a suspension
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on,
4/2, Your Honor.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisich? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
We
you.
have suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024, end
Herrera?
date 6/3/2025, and the lift date comes in at.
And then if that,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what, all I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, a court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the second and third. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment, Mr. Judge.
Thank you, Judge.
Counsel,
Judge, just to be clear, is he permitted to drive now?
as long as he has the interlock, he's got a valid license and he has insurance, yes.
Does the affidavit need to be?
Yeah, we'll rescind it. Don't. The worst possible thing you could do now is drink. If you drink, you're gonna freaking lose it. Do you understand? Or put anything in your body that has alcohol in it. Don't.
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay?
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Want to stand down for a bit?
I'm sorry?
Just,
Stand down to see if she's available to
she
Zoom?
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, Dave. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
So,
Oh, hello, can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault,
On bond.
and then he picks up an indecent.
No. Plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you.
Shh.
Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't I can't control my heart rates in these moments of panic. They're true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulted me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, asked that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently, no one's consulted her regarding this thing, see whether they.
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the
barely
plea
spoke
reasons
to you
for-
a couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. she believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely. And I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, your honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's something
I
that you
think it's
want to
unfair to
do.
my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was-
victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please,
Yes,
it's okay.
sir.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court,
I'm sorry,
in the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk and then, or we can set it for trial. It's your decision, Mr.
We do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
Okay. It's going to do 10 days, Justin. 10 days. Otherwise he loses his job.
It's better than the current deal from our perspective.
Okay.
Thank you, Judge.
Good.
Okay. Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah. Let me do this first. We'll go through with it and then, so Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement, or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this, and if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
The U.S. citizen, Judge.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was, 2 years of, okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results. All things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and SANE results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the records, the court records, after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflects my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know?
And so trial is not able to go forward.
No, the case is done now. It's ended in a deferred adjudication just now, ma'am.
Okay, and he was previously on the jury adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
The only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
I
This is the first time we're hearing about her asking for anything. And we've
No,
had
I was not.
setting after setting.
I was not aware.
Excuse me,
I
ma'am.
have all the
Excuse me.
texts of
Can you
the.
finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's
This is not the first time. I
Ma'am,
have
let me finish, please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Chavez,
documents.
I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here, okay?
Okay.
Is that it?
Yes, sir.
Okay, thank you, ma'am. Okay, so guys, for the record, please announce yourselves. State.
Anna Edie, EADY, for Mr. Wiggins.
Nathaniel Meunier spelled Munier, also for the defense.
So hold on, before you get into anything, state, you wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So Judge, I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect because it's been long enough that the protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
He is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken
I
the
have
law.
ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Edie talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal
The only
term-
way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond, thus no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And
The
not being
only
able.
way, but okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate, letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th, off the top of my head, constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms
It's not
there.
about me, Judge. It's about felony court. It's a serious issue, but that's the.
Why are
fifth
you
thing.
worried about felony court?
Because that's why he's in, Judge. Then
Well,
that's
it's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is.
There are other means for you guys to participate. But I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before, please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not gonna do it, I'm not gonna do it. And now we have 300 phone calls. So I don't know what else to do, but now back in ag seg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them, I just have to I have to do the form to get them up with the form, yeah.
Okay, so let's set up a formal hearing, because I don't want, you're right. I don't want to give you state the benefit of the doubt without him actually, or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
I think the last time that I got killed. I mean, it could be tomorrow, it'll be a few days. So, I don't know if we want to set it up for next Monday or something like that. I think I should have it by then. This is just the point that I actually connect with those places.
And if we could keep him in normal population so that we could visit him, as does his family counsel, and they
Mr.
can.
Wiggins, I'm going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ag seg. Do you understand? No. Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. I said real.
Good.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? Okay, so you want to set it for Monday?
Sure.
Okay. But just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that I truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
In the last time, he used someone else's SPIN number to make the phone calls.
That was last
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just always tell the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. Do you understand?
Sure.
Okay. Thank you, Judge.
Thank you.
Thanks, guys. See you Monday. Good morning.
I'm Mr. Arroyo on your infantry docket.
Okay.
We're here for a bail order.
And for what it's worth, you don't really have to approach. The only time is if you need something, then just for, it's a high bond, huh?
It is, Your Honor. We are requesting the PR.
Say it again.
We are requesting the PR bond, so.
Good morning, Mr. Arroyo. How's jail? Fun?
I'll say.
So February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious third-degree felon. What happened in a terroristic threat?
There's a threat, Your Honor.
The terroristic threat in our case, please.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harrison County, Texas. The officer met with a witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence and everyone exited the residence safely except for the defendant. Officer met with the witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When it was asked the defendant if he wanted to retrieve some items, and the defendant said no. The defendant came back to the residence, and the complaining witness refused to let him in. Short time later, the defendant sent the complaining witness a picture of him inside her vehicle, pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bedroom.
Like something out of a movie, like a horror movie.
A second witness, the uncle, let the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date of birth.
So tell me what happened now in the new, please, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with a witness who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. The law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. The law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that uniform. The law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, accelerated speed, and disregarded multiple stop signs for approximately 3 minutes and around 1.5 miles of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I
Is
believe
this in warrant status? Do we know?
if this wasn't warrant status, Your Honor, let me.
It was a 2B, Your Honor. It was a 2B that was filed. It wasn't so I think they're speaking about the terroristic threat family violence in our case. And it was filed as a 2B. He never was arrested on it or didn't have a court record.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's right. Since January, you've had an unlawful restraint, an assault of a family member. Now you have these 2 open cases. Why would we continue to give PR bonds?
If I may, Your Honor, the 2 previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on those cases?
I did not. I was just appointed today to him. But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and.
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give our mom, dad? Who do you have You got a son? What? You're a baby yourself. How the hell? I mean, do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
Yeah, I live with my mom.
Do you actually live there or are you out on the street all the time?
I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
In the
I
last
just-
couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a fifth?
He is now living with his mother. It sounds like before he was staying with the complainant. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
So let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street.
Sir.
If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising you. If I find that you do, I can have a contempt hearing an additional 6 months. But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir,
I'm going to put a monitor so I know where you are at all times, and then we'll talk. But first things first, not to the street. If you can verify these got a place, then let's talk, and I'm happy to do something.
Thank you.
Yes, ma'am. Yes. Good morning, Mr. Bustamante.
Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You now also have an immigration detainer. I will tell you that when you show up to court, good things happen. This doesn't have to happen. But when you continue to miss court, this is what happens. You ever pick up another charge, come to court. It's not a bad thing. You understand? Now, you will end up with a conviction on your record. This DWI will go on your record. It will be there for the rest of your life. If you ever get into a car and drive and you have the smell of anything funky, it's probably not going to go well for you. So I would never, even if you've had a sip of alcohol, get into a car and drive. After today, you will now be facing a minimum of 30 days in jail for any new cases that you pick up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to sentence you to 30 days in jail. I'll give you credit for the 90 days, the 19 days that you've done. I'm now going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir. Is your guy here?
Yes, sir.
Bring him up.
No, not at all. We have a disconnect on the reinstatement fee. Is the court requiring the reinstatement fee? I was told.
I'm not going to. I want to admonish him.
Oh, yeah, okay, cool,
Pay
cool. Mr. Fairfield, yes, yes, we.
You know,
yeah,
I'm
yes.
not, no, I was going to grant it regardless.
Okay, cool, cool. Okay, that, it was a disconnect that he came to us. Come over here, Mr. Fairfield.
Oh, yeah.
He's already in PTI.
Okay, great. He already has an interlock, right?
Yes, sir.
Okay, so you need to understand a couple things, that this license right here is on my name. You are only allowed to drive a car that has an interlock on it. This doesn't give you an open license to drive any car, only ones that have an interlock on it. Do you understand?
Yes, sir.
You also need to pay that reinstatement fee. If you do not pay the reinstatement fee, this is only good for 30-something days, perhaps 45 days. you have to get in full compliance with DPS, and then they will extend this for the full life of the suspension, which is 90 days. If you don't pay the reinstatement fee, probably after 30, 45 days, this is not going to be valid, not worth of anything. Do you understand? So I would probably pay the reinstatement fee as soon as you can. Okay, done.
Thank you, Your Honor. Yes, sir.
All right.
Have a seat, Mr. Fletcher.
Here, sir.
Bring it. Thank you.
What's new?
I've got a new case today, Mr. Romero Bennett.
Okay.
Um,
And get her.
I believe he has, and
Okay.
and so I talked to pretrial. He got tested already today. I know he's kind of told you he's on oxycodone, which he is prescribed, and so he wanted me to at least present the prescription
I can't
information.
believe that they're still prescribing it. You're telling me they still prescribe Oxy?
I mean,
They went bankrupt, didn't they?
oh, I don't know about that.
Yes.
What?
Yes, the pharmaceutical company that makes that OxyContin, they went bankrupt. They got sued, they declared bankruptcy. I guess let me see what you got.
I think I'm very generic.
I'm telling you, I don't know, maybe,
Like, he
I
has the
know that they
bottle,
went bankrupt.
and here's the prescription.
How many pills did he actually get?
His name's Sean Anjuana.
I cannot believe that they would prescribe this many. This is like an actual death sentence. It's like, this is freaking, this is like begging someone to get addicted to this. This is fucking nuts, man. These people. I'm not giving you an open ticket to use that, which is it's a literal death sentence. The problem is, Mr. Bennett, and I don't know if you realize this, but I can't tell you how many friends I've had that have died because what you do is you build up a powerful addiction to this shisa, and what happens is you keep taking, you put your lungs to sleep because of how powerful this thing, the addiction is so powerful that people convulse trying to get off. Seize.
I brought it just because it was in my system, just so you don't think I'm abusing it. I'm pretty sure my levels are down on what was in my system on the 4th.
I'm not going to ding you on it now, but I want it to stop.
Sure.
And I'm not going to continue to let you use. So
You told me since the 4th. Haven't done nothing.
great. I don't want you to. I'm still going to test you for the foreseeable future. If I know that you're done and you're not using, then I'm happy to modify it. But I want to know that you're not using. And this stuff is so powerful that I'm scared to just take off and not test, right? So I'd like to do it for some time. If he's clean for a while, then I'm happy to take off. But I just don't want you to die. That's all I want, you know, or you take someone else on the way, you know, you just can't, it's so powerful. I can't believe that they would prescribe that much, that many, just. He tests today
Yes, Judge.
and,
So the THC and oxycodone.
okay. We need to figure out when it's going to stop. I'd like to know how many are left, you know, so we can build a plan to when I know it's going to stop. I'm not going to continue to let you use. Like if I see it in 2 weeks, I'm going to have a problem with it. I'm going to tell you now. So I just be safe. That's all I'm asking you to do, you know? All right. We'll reset you. I'm going to test him next week at some point, and then we'll see how it goes.
Judge, we're still doing Monday, Thursday?
What do you want, Maverick? I want to test him at least once a week.
Once a week is fine.
So-
So I don't know what days you like to do.
I'm going to do it random. That way he doesn't know, because if he knows, he can prepare. So that's why. It's at some point next week, we'll call him to test. Okay, just be ready. Don't use, man. Don't. I'm giving you the opportunity now for you to stop on your own. Do you understand, Mr. Ben? All right, man. Good luck. Okay, thanks.
Judge, for Mr. Frederick, you'll see that a bond violation was submitted. They were given conditions by the magistrate with the GPS exclusion zone of the residence that they live. So that hasn't.
But we also need to know whether the complaining witness lives there too.
Yes, I just wanted to make it, bring to your attention that although it's an
Okay.
arraignment, he does have a bond violation from the magistrate's condition.
Okay, thanks. You are Christopher Frederick?
Yes, Your Honor.
Mr. Frederick, you're charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay. Morning.
Good morning, Judge. Thank you. On March 31st, 2025, so the law enforcement officer made contact with the complaining witness who stated the defendant is her boyfriend. The complaining witness stated that they got into an argument over the defendant and the complaining witness both stating they would break furniture. The complaining witness stated that she was going to walk out and the defendant got into a fighting stance and struck her in the face with a closed fist causing pain. The officer observed the complaining witness' left side of her face to be swollen.
So what you say, he said just struck her in the face?
Yes, Your Honor.
Mr. Frederick, I'm going to find that there's sufficient probable cause to go forward with the case. There are bond conditions that the magistrate placed on you. If you fail to live up to those conditions, if you violate those conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds for you. Do you understand? I'm going to do everything in my power to protect my community at all costs. I don't care who you are, what color you are. You're a small farm animal. If I find that you violate these conditions, I don't care what your excuse is, you will go to jail. So, Felicia, tell me, what conditions is he alleged to have violated?
It's the GPS exclusion zone. He has a GPS device with a curfew as well as an exclusion zone for the 12,000 Martin Luther King Boulevard address.
Okay.
However, it also seems to be the residence of Richard Collins.
Okay. Have you guys done a rip on this case? Do you know?
I believe we've attempted one, Your Honor, but we've not made contact yet. Or, I'm sorry, I apologize. We have made contact now, Your Honor.
What does she want? Does she want to have contact with him? Does she not want him to go back? Mr. Frederick, do you have the ability to hire a lawyer?
No, I don't.
Okay, I'm gonna need you to fill out an application for me. I need to know whether you qualify. We don't just give out court-appointed lawyers like it's candy. You have to qualify for it. So what we'll do is Deputy Miranda's gonna give you an application. I need you to fill it out. I need to know everything about you, what money you have in the bank, what kind of money you make, what kind of job, cars. Let me take a look at it. I'll see whether you qualify. Do you currently have a monitor on you now?
Yes,
Okay, you are not allowed to go back to this house. I don't know whether she wants to have contact with you until I know. I'm gonna honor these bond conditions. Do you understand?
Yes.
Okay, so let's first see if you qualify for a lawyer. If you do, I'll give you a lawyer and then we can go further. Deputy Miranda's gonna give him an application. I'll have you sign a reset and then we'll have you take a seat in the jury box.
Go ahead.
Your Honor, this is like you said. They were living together and they no longer live together. I'm not sure if that means she moved out of the residence and she lived in the residence.
See, maybe we can get it done a little bit later today. to see.
Yes, Here's my approach. I just want to let you know the seal of the pretrial had already come and told us that she no longer lives there.
Come on. Took all your conditions off. We took off all your conditions. We took the GPS monitor off. We took the curfew off. Just the restriction for you to go back home. The only thing I'm asking you to do is don't have contact with this person. Okay, we took everything off. Go live your life. Just don't have contact with this person. Don't be in possession of weapons. As long as you can have that, I'm happy. And then just live your life. Don't get in trouble. You know? Okay, we're giving you a lawyer. Just you need to stay in contact with them. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Harold and he'll tell you if and when you have to come back to court. Okay? Okay, man. Have fun.
Thank you, Judge.
You are earnest.
Because what you just witnessed does not happen often in any courtroom in America. A sexual assault case, reduced from a felony to a misdemeanor indecent assault, set for trial 7 times in 1 year. A new prosecutor assigned days before the plea. And then the victim, on Zoom, reading her own statement out loud before the deal was signed. She said, he took his mother's car while he had a breathalyzer installed in his. He drank heavily. She was in and out of consciousness. She said no. She pushed him away. She froze and said that freezing was not consent, it was survival mode. She said the previous prosecutor told her that juries don't believe women. She said she was told she could be blamed for going to the bar or for texting him afterward. She said, what kind of system lets someone walk away with that and just probation? And the judge, right in the middle of the agreement that was already arranged, already agreed to, already on paper, stopped and said, I'm not taking it. Not like this. Not without 30 days. So here's the question that I want you to sit with. The law gives victims the right to speak, but it does not give them the right to stop a plea. What this judge did, refusing the deal mid-hearing after hearing her voice, is rare. It is not required, and it changed the outcome. So what does it mean when justice depends not on the law, but on whether a judge is actually listening? She said, "I still feel like I'm being silenced." The judge said, "I am glad you are here," and then he modified the deal. 10 days as a condition. The defendant pleaded guilty anyway, and the case ended. Not the way the lawyers planned, and not the way she asked for. Somewhere in between.
You are Ernesto Hernandez. Sí.
Yes.
Mr. Hernandez, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney represent you. If you cannot afford one, one will be appointed to you, sir. Okay.
Judge, on March 31st, 2025, in Harris County, Texas, law enforcement officer was flagged down by the complaining witness who stated that a vehicle was driving the wrong way down a one-way street and damaged the complaining witness's vehicle and did not attempt to stop. The complaining witness stated he followed the defendant to a dead end and called the police, then found the law enforcement officer. The complaining witness then showed the law enforcement officer where the defendant's vehicle was parked. The law enforcement officer found the defendant asleep behind the wheel of his vehicle. The complaining witness was able to identify the defendant as the individual who was driving the vehicle at the time the damage occurred. The complaining witness estimated the damage to be $802,000.
I'm sorry, the amount
$800 to $1,000.
entre 800 a $1,000.
So he hit the vehicle and
Así
took.
que él le pegó al vehículo
Hear that you, and how far did he go?
y que tanto
I'm not
siguió.
sure.
Dice, no estoy seguro.
It occurred near
Eso ocurrió cerca de
340 South 69th Street.
342 Sur,
And then there
calle
was a dead
69,
end
entonces sobre la calle sin salida,
that the defendant was parked at
donde
300
estaba
South
estacionado el
7th
acusado,
Street.
cerca de la calle 70.
Read the part where the accident,
Dice,
please, if you
lea
don't
la
mind,
parte
into where he took
cuando
off.
ocurrió el
Yes,
accidente
Your Honor.
hasta dónde.
I didn't hear it.
Complaining witness stated a
El
vehicle was
denunciante
driving
dijo
on
que
the
un
wrong way
vehículo
of
iba
a
en
public
otro
roadway.
sentido, en una
That
carretera
is a one-way
pública,
street.
que era una calle de un sentido.
And the complainant said that the defendant
Dijo que el
damaged
acusador
his
dañó
vehicle
su
when the
vehículo
defendant was driving the wrong
cuando
way and did
estaba
not attempt to
acusado,
stop.
estaba manejando
Has
en
the
una vía en
difference, Your
contraria. Entonces no paró y dio información.
And then he goes to a dead end street
Es una calle sin salida.
Yes, Your Honor.
Sí, sí.
and falls asleep.
Yes, Your Honor.
Do we know if alcohol is a factor?
Ha consumido
It's not
alcohol.
alleged, Your Honor.
No se alega eso, su señoría.
I'm not sure that there was any
No estoy
investigation.
seguro si hubo una investigación.
Mr. Hernandez,
Señor Hernández,
if there's
puede
sufficient
encontrar
probable cause to go
suficiente
forward
causa para seguirse adelante con su caso.
on his license, please.
Yes, Your Honor.
If you do not have a Texas driver license and liability insurance in your name, you are not allowed to
No se le
drive.
permite manejar.
Do you understand?
¿Entiende?
If I find that you do,
Usted
I will put you in jail.
vamos a meter a la cárcel.
His license is eligible.
I don't know what your immigration status is, but if you're not in this country with permission
En este
and you
país.
go to jail and immigration finds you,
No
they
encuentra
can possibly put a detainer on you and you will be stuck like Chuck in there
como yo.
until this case is over with. Do you understand?
¿Entiende?
It
Yes.
is a bond condition that you're not allowed to drive unless you have liability insurance as well. Do you have the ability to hire a lawyer?
Has de contratar un abogado.
Sí contraté uno.
Yes, I hired one,
No, no ha llegado, yo creo, no sé.
but he hasn't gotten here. I don't think so. I don't know.
Oh, Judge, I
I don't
called
see
this morning and they said that the attorney had to go to a different court, but he was going to be on his way. And
Do they
they thought they were
identify
following up.
who?
La oficina.
See anything filed
Yes,
there?
yes.
Oh, you do? Who is it? 'Cause I don't see it. That's
It is Mr. Pass.
David Pash. Okay. So what we'll do now, Mr. Hernandez, is I'm going to have you sign a receipt, Victoria. We will have you take a seat at the jury box while we get your bond conditions. We will also wait until your lawyer arrives.
Su abogado.
Please, do you mind filing no driving without both?
Yes, Judge.
Good morning, Mr. Shea.
Good morning.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I'm sorry, I missed that.
SHA.
On March 30th, 2025, in Davis County, Texas, an officer was dispatched to a family disturbance call. The officer met with the complaining witness who stated that the defendant is her husband. The complaining witness stated that the defendant and her son, who has mental health issues, got into an argument where the defendant slapped her son in the face. The complaining witness then intervened by getting between them. The defendant then grabbed her by her hair and pulled it, causing pain. The defendant then left to the garage, saying that their children would grow up without parents.
Judge, if I may, they did a rip call, and in the rip call, it indicated that she didn't feel any pain.
Judge, let me clarify what the recall says specifically is that she got in between them and he grabbed her hair a little bit. If Plea was reiterated, that this hasn't happened before and that she was not hurt. It does not say she didn't feel pain, just that she was not hurt.
Did the officers ask whether she felt pain at the time?
The judge says that the complaining witness stated that the defendant grabbed a hold of the complainant's hair and pulled it hard, causing her to feel pain. That's as the injury.
It does say that.
It does say that the injuries grabbed a hold and pulled it hard.
Mr. Shape, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know whether she wants to have contact with him? A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up.
The complaining witness is asking to drop charges and to drop whatever bond conditions exist, Your Honor. I don't know if that's...
So what I'm going to do is I'm going to order you not to have any threatening or harassing contact with this person. If I find that you do, I will revoke your bond and put you in jail. You need to understand that what is threatening or harassing doesn't matter what you think. I could care less what you think. It's what she perceives. Do you understand?
Yes, Your Honor.
And you've got a lawyer. The lawyers will take care of you. I will waive your appearance so you don't have to waste your time coming to court, but stay in touch with them. They'll tell you if and when you have to come back to court.
Thank you, Your Honor.
Do you mind filing no threatening or harassing conduct?
Yes, Your Honor.
And we can amend the MOA approval as well to take off the residential restriction.
Thank you, Judge.
All right, sir. So what I'll have you do is we'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We're going to get bond conditions created for you. Once you sign them, after that, you'll be free to go. Do not leave until you sign the bond conditions though, sir.
Thank you.
Okay, thank you.
Thank you, Judge.
Good morning, Mr. Reyes. Morning. Sir, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, a law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of South Highway 6, turning left. The law enforcement officer turning left at a high rate of speed. The law enforcement officer made a U-turn at the intersection to follow both motor vehicles having to travel approximately 66 miles an hour in a 40-mile-an-hour zone. Law enforcement officer observed the motor vehicles to be side by side with the Honda flashing emergency lights. Law enforcement officers observed the Honda turn off its lights, and both motor vehicles began to speed up again while driving side by side and run a red light. Law enforcement officer attempted to catch up to both motor vehicles, causing the law enforcement officer to travel approximately 90 miles an hour in a 40-mile-an-hour zone. The law enforcement officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. A traffic stop was initiated and the law enforcement officer made contact with the driver. The defendant stated, when asked about the high speed, no, I was on my way home with my friend Adam, and Adam was following me home. Co-defendant arrived claiming he was there to check on the welfare of the defendant. Co-defendant stated, I was following home, but I broke off because I wanted to get something.
So we do have a co-defendant?
I believe
you know. Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? If he has a license.
Yes, Your Honor. And we do have the co-defendant in this case.
Got it. I'm ordering you as a condition of your bond not to participate in this type of activity anymore. You're not to race, do any street takeovers, donuts, driving maniacally. If I find that you do, I will take your privilege to drive away from you, and then I'm going to put you in jail. Do you understand?
Sir.
I'm not asking much from you. I just want my streets to be safe.
Eligible, Your Honor.
Okay, you're also not allowed to drive unless you have liability insurance in your name. All those are conditions of your bond. You violate that, it's not going to go well for you. You understand?
Sir.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Roth, and he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're playing games, likewise, I will revoke your bond. We'll have you sign a reset with Victoria. We'll have you take a seat while we get your bond conditions. You'll sign it, and then you'll be free to go, sir.
Yes, sir.
Thanks. Thanks. Take care.
This one was PHA. We already filed a PC.
Oh, we did?
Just
Okay.
the hiring attorney.
Got it. Okay. So if we have the bond conditions already in there, then free to go. Okay, all right. Thanks.
You
Please.
come.
Yes, yeah.
Good morning, Judge.
Hi, how are you?
I'm good, thank you.
I'm Geronimo Tapia.
Yeah, it's a plea.
Ready? Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail. Hey, please. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but it's not dismissed. You cannot tell people it's dismissed. It's if you complete it successfully, you just don't end up with a conviction. You understand? There's a big difference. Now, for you to complete this successfully, you must do a DWI education class, an effective decision-making class, 2 victim impact panels. You must also do a TRAS. This is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them as well. No drugs, no alcohol, guardian interlock, and substance abuse treatment as needed, as indicated by the TRAS. Is this how you understand the agreement?
Yes, Your Honor.
There is also no breath test refusal, meaning that if you were pulled over, an officer asks you to submit a breath test while you're on this probation, you must submit a breath test. If you fail to do so, then if you fail to complete any of these conditions, we issue a warrant for your arrest. We're going to have a hearing whether you violated this probation. If you do, you're looking at 180 days in jail. Do you understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it or it gets revoked. Do you understand?
Yes, Your Honor.
How do you plead to the offense, guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 15 months. If you ever have a problem, all you have to do, come back. We can work through anything. The worst thing you can do is take off or start consuming alcohol or pick up a DWI. You understand?
Yes, Your Honor.
Now, we all make mistakes, Mr. Geronimo Tapia. That's why I will waive this supervisory DPS fee. This is normally a $3,000 fee, but if you come back with another DWI, it is a $6,000 surcharge. Not to mention, you're looking at a ton of time. Do you understand?
Yes, Your Honor.
If I were you, even if you've had a sip of alcohol, I wouldn't get into it. Officers don't care. All they look at your record, if they see a prior DWI, it's not going to go well. Do you understand? All right, good luck. Thanks, Josh.
Your Honor, I have 2 pleas, one of which is Mr. Son Agriano, and the next one is Mr. Mosiah McIntosh. Yes, sir.
Judge, just for the court's record, Mr. McIntosh did go to the drug test today and it was negative.
Oh, great.
Okay.
All right. Good morning, Mr. McIntosh.
Good morning, Judge. How are you? Yes, sir. Not to the judge. Okay. Judge gonna ask you how you plead guilty and not guilty guilty. Yes.
So are they going to dismiss one in exchange for the
That's
other?
correct, Judge. On each one of these clients, they, hands out your pocket, sir. The estate is going to proceed on Mr. Agriano. The state is going to proceed on the 2526700 case.
The other one's going to be dismissed.
Yes, sir.
Both of you guys are charged with multiple cases. Both of you guys have worked out agreements where they're going to dismiss one in exchange for the other. You both need to understand, and Mr. McIntosh, you need to understand that you're pleading guilty to a theft. This theft will go on your record. It's going to be there for the rest of your life. So no deferreds, they didn't offer deferred anything?
Yes, I sat with him inside the office, Your Honor, and I went over the whole ordeal about what effect a theft conviction would have on him. I told him it's a crime of moral turpitude. It will hinder him for the rest of his life.
You know, in life, when you take a half-ass approach to something, you get a half-ass result. When you plead guilty to something and when it goes on your record, it's never, you're stuck with it forever. Do you know that I have people that call me now that say, hey, can you get this theft off my record? I can't get an apartment. You literally, people will deny you an apartment because you have a theft on your record. You know that? If you want to get a loan for a car, if you want to buy a new car, you came into a lot of money. Nope. It bars you from so many things. You're old enough to know actions have consequences. If you want to do this, then I'm more than happy to take it. But once you take it, that's it. I'm sure that they would offer you a short probation, do an anti-theft class, and you know, you don't end up with a conviction on your record. But once you plead guilty, that's it. And theft cases, you're branded a thief for the rest of your life.
How long would the probation be? I told you 12 months, sir.
And I tell you what, I'll make it sweeter. I'll take you off in half the time. But once you get that theft, so I'll take off all your fees. You won't know anything. Never about the money. I don't care. Just you tell me. You don't have to make a decision now. I'll let you talk with Mr. D. You let me know what you guys want to do, okay?
There you are.
So, Mr. Anguiano, you have worked out an agreement. They're offering you a 12-month deferred. This is a type of probation that if you complete it successfully, you don't end up with a conviction on your record. But you can't tell people it was dismissed. It's not dismissed. You just did a probation, completed it successfully. You don't end up with a conviction. Do you understand?
Yes, sir.
You also need to understand that you give up nearly every right known to man by entering into this agreement, that if you violate this agreement, we issue a warrant for your arrest. You're looking at 180 days in jail. Do you understand?
Yes, sir.
All you have to do is a thinking for a change and a TRAS. This is an evaluation to see what other conditions you may need. You have any kids? The other agreement is 25 hours of community service. I'll make you a deal. If you do a driver safety course, I'll waive the community service. That way you learn something from this. You know, it's just keep our streets safe.
Thank you, Jeff.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, that's it. If you get this thing done in half the time, get all your classes done. Don't pick up any new cases. Don't test positive. I'll take you off in half the time. Can you get it done?
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'll withhold it. All you got to do is a TRAS, thinking for a change, 25 hours of community service. But if you do the driver safety course in lieu, you don't have to do the community service. And no drugs, no alcohol. If you ever have any issues, come back. We can talk about it. She's amazing. She'll help you however you need. All right? All right. Wave your
Judge, I think there should be an inclusion of clients getting his GED, Judge. The chief and I discussed it.
Yep. Done. Do you have a driver's license?
No, sir, yet, no, you aren't.
I think that's important. If he's going to start driving, you need a license, man. Don't drive. Don't drive until you get a license. Do you understand?
Yes, sir.
I want you to get your GED. That's the most important thing in your life as well. All right? All right. We're going to give you a list of resources so that you don't have to pay anything to get your GED. All right? All right. Good luck.
Thank you, Your Honor.
Just let me know.
Yes, sir. We will go talk, Judge.
Mr. D.
Yes, sir, Your Honor. The chief and I need to talk to you about something, Your Honor. it's my understanding that the chief is not amenable to 12-month deferred on the one of the thefts. It's my understanding that he's willing to accept 18 months. However, he said he would.
I'm okay with whatever.
And Your Honor, I said I didn't come to you too. The only reason, Your Honor, there was a PTI from 2023 on misdemeanor. It was the case was the PTI. Then we had the theft, a new theft.
What was the original PTI on? Not on a theft though. Interference.
Your Honor, I'll come to you. Obviously, I'll just give that option. I just think given.
You want to do an 18-month deferred?
I would offer it.
What do you think? Because we can always early
He
terminate.
just told me he wouldn't be willing to do an 18-month.
Well, but what I'm telling you is if he does well, I'll terminate him early.
I told him that he would terminate it in 9 months.
Come on up. Your alternative is a conviction. And I'm telling you now, the conviction will hose you for the rest of your life. We're trying to save you from yourself because sometimes people are their own worst enemy. And that's you now. You're continually shooting yourself in the foot. Life is hard as it is. And when you start racking up convictions, especially theft convictions, it just gets so much worse. I promise you, it's not fun. This life is about one thing. It's about having fun, making a lot of money, getting to buy nice things, going on nice vacations. And when you get that theft conviction, no one gives you a job. No one's going to give you because they know that you're going to steal from them, given the opportunity. That's why we have convictions, to put the entire world on notice of what type of person you are. That's why you want to avoid as many convictions as you can. Because once you get that notice, and once the entire world knows you're that type of person, they don't give second chances. Very few times. I'll do whatever you want to do. If you want to take a conviction, you can do it. If you want to do the deferred, what we do is we reward you. If you do well, we take you off early. It could be 6 months. It depends on you. If you get it done really quick, I can take you off in 4 months. I can take you off in 6 months. It depends on how well you do it. You're the master of your own domain.
I'll
I'm
take,
just trying to save you from yourself.
Is this the final
yes, sir.
decision?
Yes, sir.
It's up to you. They can write it up for 3 years, 4 years, 5 years. I'm the one that can early terminate you, right? And that depends on you. If you do well, you don't test positive, get your stuff done quick, we'll take you off quick. The idea is that you learn from this, so you don't pick up another case. At some point, you're going to get the itch to take something. Don't. It's just not worth it. You know, whatever the stupid ass thing in the store that you want, just don't. Work and you get it on your own. You know what I mean?
So,
Okay.
Thank you.
Whatever you want.
thank you, Your Honor.
Okay. All right. Make the right decision.
All right, Mr. McIntosh, this is a good deal. I hope you do well, you know?
I will.
The agreement is,
18 months.
it's an 18-month,
MZI.
I didn't print out the new one.
18 months, yeah.
all right. Okay, so they're going to, yeah, I got it. They're going to dismiss the one and then he's doing a deferred on this one,
Yes,
right?
sir, Your Honor.
You know, the thing is that if you complete this, Mr. McIntosh, you will have no convictions on your record. You know, we're sending you out in the world better than you came if you can complete this. You know, we're not asking for much. The agreement here is an anti-theft class, a TRAS, no drugs, no alcohol, and 25 hours of community service. Are you working? What do you do with yourself?
I just started with Bacon Temp Agency,
Okay.
and I just got an interview with Jovi's full-time as a butcher.
Did you graduate from high school?
I graduated from high school, and I'm doing Coursera, automation, IT,
Great.
online.
As long as you get the anti-theft class done and you work full-time, I'll waive the community service. Just make us proud, get the theft class done, stay out of trouble for at least 6 months, you're out of this thing. Okay, we'll early terminate you.
Thank you.
We're gonna waive all the fees, you're not gonna have to pay for anything. I can't pay for the class, you'll have to pay for that. But I'm taking fees off for everything else,
Thank
okay?
you, Your Honor.
You give up a lot of rights by entering into this agreement. You give up the right to have a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you're stuck with us until you complete it successfully or if you get revoked. Now, if you do well, no conviction. If you fail, like you pick up a new case, you don't do your anti-theft class, or you test positive for something, I'm going to issue a warrant for your arrest. I will put you in jail, and you're looking at 180 days. You understand?
I understand.
We're not asking for much. All right? All right, so I'm going to follow the agreement. We'll sentence you to it. Good luck to you, sir.
Thank you,
Did
Your
he say
Honor.
guilty or no?
He said guilty, Judge.
Okay, all right. Look, Mr. Matt.
Thank you, Your Honor.
That's all right. That's it.
Thank you, Your Honor.
Thank you, Mr. Deacon.
Yes,
Thanks
sir.
for being so patient. You are Tavion Williams.
Sir.
Mr. Williams, you now stand charged with yet another case. Terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 30th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance and made contact with the defendant and the complaining witness. The complaining witness and the defendant were in a previous dating relationship for 3 to 4 years. The complaining witness stated that the defendant was upset because the complaining witness broke up with him. Complaining witness stated that the defendant had called and texted her multiple times. On one such call, the defendant stated that he would go to her location, punch her in the face, and break her phone. The complaining witness stated that she then stopped answering the defendant's calls. The defendant then showed up at her location and attempted to make contact with her multiple times and grabbed her arm from across the counter. The complaining witness stated
And did what?
grabbed her arm from across the counter. The complainant witness said she was in fear for her life. Witness, the complainant was probably confirmed the events and then also described another incident. The event showed up to complaining witness's job and threatened her life.
Since December of last year, Mr. Williams, unlawful carrying of a weapon, felony UUMV, evading arrest, gun case, felony gun case, and now a terroristic threat. Within a matter of 2.5 months, you have picked up 6 cases. What on earth is going on with you? We will now find out. I'm ordering you now to go take a drug test, and you will return tomorrow so we can fulfill the bond conditions. If you so far as have any contact with this person, I'm going to make your bond so high you'll have teeth falling out. Do you understand? You are not to be in possession of any weapons, and I'm going to put a monitor on your ankle so I know where you are at all times. The next case you pick up, I'm going to freaking lose it. Do you understand?
Yes, Your Honor.
So I'd like to send him for a test now, and then right afterwards, he gets a GPS monitor, not to go within 500 feet of where the complaining witness lives, works, no weapons, no drugs, no alcohol, and then we will return tomorrow to discuss the results. We will also, in the interim, give you an application to fill out, and you can bring that back tomorrow to see whether you qualify for an appointed lawyer, sir. You know, Mr. Herrera, so you talked about a PTI and he doesn't want it?
They denied it, Your Honor.
Oh, it's denied?
Yeah.
Okay. So, Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will now go on your record. It's going to be there for the rest of your life. I would never, even if you have a sip of alcohol, I wouldn't get into a car. When they look your record up, if you get pulled over and an officer smells it, it's probably not going to go well for you. And what we're doing today, from now on, it's a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand?
Sir.
Judge, I don't know what the credit or the time was, but he has 1 day credit. I'm not sure what.
So whatever it is.
Okay.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this?
Yes.
How do you plead to the officer, guilty or not guilty?
Yes.
Are you sure? If you're not guilty, then don't plead to it, man.
Oh, no, yeah.
Because once you plead, you can never change this. This isn't Target where you can return it because you don't like it. Are you sure? Okay. I'm going to find you guilty, Mr. Herrera. Let me make something else abundantly clear to you. Your lawyer is asking for me to waive what would otherwise be a $3,000 surcharge that would normally apply to you. We all make mistakes. But if you continue to make mistakes where you endanger other people's lives, that's when the sentences get a lot more serious. A second DWI, like I said, it's a minimum of 30 days in jail and a $6,000 surcharge. So if you come back with another DWI, do you understand? If you want to get lit, take an Uber. $40, anywhere you want to go in this city. How much money have you spent? You know what I mean? Good luck.
Your Honor, I'm here on Mr. Terrence Robinson. Looked like Mr. Terrence Robinson had an outstanding case that was unbeknownst to him. Looked like he posted bond on that case. Looked like it was an assault case. I think it was last year, 2024, but he just got arrested for that case. He posted bond, he posted bond before he got rearrested for it. Well, he never was arrested because it was a 2B. But they posted bond on that case. But the case was before the new case that we have.
October 18, 2024.
Right.
Come up, Mr. Robinson.
Yes, it looks like it's a late filing, so they filed with the sheriff.
Who's the complaining witness in the assault case?
It is a, it says acquaintance, 19-year-old, just going through now.
So it looks like this case was in October of last year before this terroristic threat. So we're not going to do anything to the bond. Okay? Just be careful. Don't have contact with the person in the assault case.
May I ask one question, Your Honor?
Sure.
I just moved off of my netta and wondering when I get back to the new outreach community church program and get the address, I'll make sure I give it to my lawyer because nobody's given it to me since I moved there yesterday.
Okay, just all we ask is don't have contact with these people. Don't go over there. Just don't talk to them, and all will be well if you just.
Yes, sir.
That's it. And no weapons too.
Oh, yes.
So we're going to create bond conditions for you. We'll have you sign it, and then you're free to go.
Okay.
I just bought what they gave me when I got out. It was a G.
But they put your
You already
GPS.
posted bond on that.
Sorry, Your Honor. I'm sorry.
Did they give you a GPS?
He had the bond already,
Oh,
Judge. He
okay.
just posted bond. He has the bond on the case.
You got a free bond, right?
Yes, sir.
Yeah. Okay.
Yeah.
Got it.
Sorry.
All right, take care.
Did you find PC on the new one? Or?
Oh,
It was,
have we not done PC on it?
Tomorrow.
Oh, yeah, he is set tomorrow.
I guess let's do it. Please.
Officer was assigned to a case follow-up investigation for an assault bodily injury that occurred on 10/18/2024. Officers made contact with the complainant. Complainant stated the incident occurred on the corner street bakery near Main Street Square. Complainant stated that he was talking to a friend. Complainant stated that he was sitting down. He saw the defendant grab a metal water bottle and threw it against the head of the complainant. Complainant stated this caused him to lose consciousness and a laceration on his head. Complainant stated he felt pain. Complainant stated he ID'd the defendant. Complainant texted the officer an image of the injuries. Officers stated that the image showed a laceration of the complainant's head. Officers created a photo spread using the defendant's most recent mugshot. There was a photo, a six-pack lineup spread.
So both just complete unknowns. It doesn't.
It appears that way, Your Honor. It does show in the office report that they were acquaintances. But I don't, sometimes they say that and it's not the case. But a mugshot was done and a mugshot lineup was done.
The defendant ID, sorry, the complainant ID the defendants. They met with the complainant on 3/19/2025 when they administered the double-blind photo spread, and he positive ID the defendant.
Understand, all we want, Mr. Robinson, we want our street safe. We
Yes,
don't
sir.
want people that are walking down the street and they're scared to walk down the street because they're going to get assaulted,
Yes,
you
sir.
know? You now have 2 open cases. Don't pick up a third. It's just not going to go well. So don't have any contact with this person, no weapons and all is good. All right?
Yes, sir. Yeah, my word.
They're going to create the conditional, have you sign it, and after that, you're free to go.
Yes, sir.
Thank you.
And Your Honor,
Yes.
no contact, no comments.
Today's docket had a lot of moving pieces, and most of them moved quietly. But one case did not move quietly at all. A woman zoomed into her own sexual assault hearing after being told days earlier that a plea deal had been arranged, a deal she had not been consulted on by a prosecutor she had just met that week. She read her impact statement before the plea was taken. She described flashbacks, panic attacks, a career as a hairstylist she could no longer do because she cannot be alone with male clients. She described freezing as survival mode. She described being driven home afterward and being bought a Plan B pill the next morning. And she said out loud, "What kind of system lets someone walk away from this with probation?" The judge listened, and then he rejected the deal. The lawyers had brought him. He said, "I am not doing this without 30 days as a condition." The lawyers negotiated it down to 10. The defendant accepted. The judge entered a 2-year deferred adjudication, a no-contact order, testing, and mandatory classes. The case was over. The victim asked for more: a formal admission of guilt, sex offender counseling, the right to pursue civil litigation preserved in writing. The judge told her, "I cannot give you those things from here. Go talk to the district attorney's office. Go see a lawyer." She said, "I still feel like I'm being silenced." The judge said, "I am sorry. I appreciate you being here." A man in custody on a felony was found to have made 293 phone calls to the victim in his case since March, including 28 in a single day. His lawyer argued that segregation would violate his constitutional rights, that the jail could block the number instead, that there were less restrictive means. The judge made him sign an affidavit under oath promising to stop, set a hearing for Monday to review the call records, and left him in general population. A young man with 6 open cases in 2.5 months, unlawful carrying of a weapon, a felony vehicle, evading arrest, a gun case, and now a terroristic threat against an ex-girlfriend who he showed up to her job to threaten, was sent for a drug test on the spot and had a GPS monitor placed on his ankle before he left the building. A man with a CDL and a scram monitor had his bond violation hearing thrown into doubt when his lawyer produced an ALR dismissal order, showing his license had never actually been suspended at the time he was ordered not to drive. The judge found probable cause to believe he had technically violated a valid court order anyway, because a court order is a court order, regardless of what pretrial services told him, but let him go because the license was valid on the dates in question. And a judge looked at a young man facing a theft conviction and spent 10 minutes trying to talk him out of pleading guilty to it, explaining that a theft conviction follows you to every apartment application, every job interview, every loan, and then offered to terminate him early if he stayed clean. The man took the deferred. The judge said, "We are trying to save you from yourself." This courthouse heard a lot of voices today. Not all of them got what they asked for, but most of them got heard. We will see you in the next one.